Welcome to the DC Bar Community's Law Student Podcast with your hosts,
Melody Al-Mansour, third-year student at Georgetown University Law Center.
Elena Hoffman, first-year student at the George Washington University Law School.
Renata Mitchell, second-year student at the George Washington University Law School.
And Alexis Bird, third-year student at UDC David A. Clark School of Law.
You're listening to Let's Brief It.
Welcome and thank you for listening to Let's Brief It, the podcast made for law students by law students. My name's Alexis Bird.
And I'm Renata Mitchell.
And today we're going to talk a little bit about intellectual property law, and in particular, the increase in patent litigation that's related to artificial intelligence. So to help us tackle these issues today, we're joined by our guest, John Nappi. John is an attorney at Finnegan here in the District of Columbia, where his practice includes patent litigation before the U.S. International Trade Commission, the Patent Trial and Appeal Board, and the U.S. District Courts. John also has experience with various stages of patent prosecution with applications in both the chemical and electrical arts. So today he's going to talk with us a little bit about his career, his trajectory in IP law, and to give us a general overview of this growing area of the law. So thanks, John, for being our guest today.
Thank you for having me.
Thank you.
When we were reading about you, we noticed your extensive expertise in patent litigation. Can you talk to us a little bit about your experiences and how you got into this practice area?
Sure, yeah. The majority of my patent litigation experience has been in district courts with mainly pharmaceutical patents, generally representing brand name drug companies in what's called a Hatch-Waxman case, or people call it an ANDA case, which is an abbreviated new drug application for short.
Gotcha.
ANDA's more catchy. I've also represented clients in front of the International Trade Commission, the ITC, that was related to a printer cartridge technology, actually, so totally different. But I've been practicing for about 6 years, and as you mentioned, sprinkled into that has been some patent prosecution, not so much lately, but it has been a good opportunity to get a more well-rounded view of patent law in general.
And what about your academic experience? Like, do you have a science background? I know that's pretty common in the patent space. Or
Yes, I have a degree in chemical engineering.
Okay.
And I worked for a couple of years as an engineer and liked it, but didn't like being behind a bench all the time and fumbling with equipment constantly. So I started to explore kind of what else I could do, but still, keeping that tech background relevant, and it is definitely something I use every day.
So what are some of the most pressing issues today affecting the IP law practice?
Oh, that's broad. So, there's a couple things. You mentioned artificial intelligence earlier. I think, one thing that's still a little unclear is patent eligibility with respect to essentially a lot of computer science kind of patents. There has been, over the past, I want to say about 5 years, an increasing amount of litigation over what scope of computer programming or software, things like that, are actually patent eligible. And part of the problem there is if there have been cases where if a computer is doing something that anything else can do and it's only simply a computer doing it, the question is that patent eligible? We're starting to see some distinctions in the law as they move through the courts to figure out, how broad, how narrow should that exception be. Other than that, recently there was, the TC Heartland case having a effect on venue. A lot of patent cases were brought in the Eastern District of Texas, and for a long time you could bring a patent case really anywhere where a party was potentially selling a product, and with the internet that's really the whole country. And so a lot of patent cases, especially in the tech field, are being brought in Texas, and it's a very small jurisdiction. There was a lot of question over whether that was really proper, why this place over everywhere else in the country. So there has been a bit of a swing back to district court cases being brought in places that make more sense based on where companies are located. But that being said, I've been on a few cases that are in Delaware because so many companies are incorporated in Delaware.
Right.
So that doesn't
Very
necessarily...
friendly business laws.
Yeah. So a case I'm on right now is we're going to trial soon is in Delaware. So it's pretty
And
common.
so was that similar with the TC Heartland case? Because I remember hearing in the past that so many patent cases are filed in the Eastern District of Texas. So that's the case that those companies are headquartered there, or that they just choose to file?
Companies choose to file there because
Okay.
it was considered, and I don't have stats on this, but it was had the reputation
plaintiff-friendly, right?
of being patent friendly.
Yeah.
And so that was just a choice that was made, and there was a lot of complaints about that. And so now it's harder, I think, to bring suit in a specific jurisdiction without a better reason than just I like it.
Right. So then we know that, it's not often considered a sexy area of the law, but why do you think that law students should consider pursuing careers in IP?
Well, I think it's the best area of law. I think it depends. So IP is really broad, Yeah. IP is really broad. You had mentioned you have a background in music and kind of the more arts-oriented parts, and that is an area where IP law intersects very strongly in copyright. And you have business focused trademark kind of a section of IP, and then you have the more tech focused patent section of IP. So what I really like about it is how broad it is. That also makes it difficult because like this, you have someone come in and you try to talk about IP, quote unquote, and it's such a broad area. I don't think anybody practices in all different, in depth in all three parts of IP, and trade secrets would be the fourth part. But I think especially if you have a background that is not just pre-law, if it is something that is, music, arts-oriented, if it's science-oriented, you can really use your background that you've, presumably had an interest in and have experience with, and also use your law background too.
As someone who's interested in practicing copyright and trademark law, a common question that students ask is if you have to have a technical background in order to practice IP.
Only for patent, and that's not a hard and fast rule, but it's very helpful, and employers usually look for it. But if you're interested in copyrights or trademarks, no. I don't, of the practitioners I know that work in those areas, predominantly they don't have a technical background. They often have a background that is in, publishing or music or something that for copyright, really naturally progresses into that. For trademark, that's more of a mix, but there's no technical requirement for it. If you do want to be patent barred and to take the patent bar to be able to represent clients in front of the patent office, either in patent prosecution or in front of administrative law judges, then you do have to have a set of technical credentials, which can be a degree, it can be experience. There's different ways you can get there, but to sit for that bar, you actually have to have a technical background.
Okay. So we recently read an interesting article about artificial intelligence and the increasing patent litigation surrounding it. AI is everywhere. It affects every part of our lives, from telecommunications to transportation and medical sciences and gaming. And I just wanted to get your thoughts on the impact that AI is having now in society.
Yeah, I don't think we've even touched the surface of the issues we're going to see with artificial intelligence. I think, just from an initial perspective, if artificial intelligence essentially is computer programming, how should that be protected by intellectual property? Is that patent eligible? Is it a copyright issue if it's code? As AI progresses and actually starts to, really learn and make decisions, should an artificial intelligence program create something, who should be the inventor of that? You have laws that natural persons are what should be listed as the inventor, and that's why companies aren't inventors. It's always the people that did the work, and then they assign their rights to the company, and then the company effectively owns the patent. But what do you do if you have a computer designing something or a computer creating something? Is it the writer of the code? It can't be the computer. I just don't know what's going to happen. I don't know what's going to happen with that. That's really interesting. And even from, going back to what I was saying before, just actually getting patent protection on that artificial intelligence, I think there's going to be some people are going to have to figure out how to actually do that. And there's going to have to be decisions at the patent office and then probably at the federal circuit and maybe higher about how do you do that? How do you connect that code or that program into a computer or into something physical to give it patent protection?
What other areas of IP law do you see AI issues infiltrating?
I think if you have artificial intelligence programs creating copyrightable material, then you're going to have the same issues you're having in patent. Can a computer program, or is it the operator of the program, gets the copyright on, if the computer program is writing poetry, I could see that happening. Who gets the copyright on that? I've also read an article about the perfume industry. And so perfumes and colognes are normally made by people knowing different scents and combining them and knowing what people generally like. And I was reading an article yesterday, actually, about inserting all that data about what components, what scents make up the most popular colognes and perfumes, and having the computer determine different combinations of things that would be a new perfume or cologne, or maybe areas of the market where there are gaps in scent profiles. And I really think it's going to be anywhere that people are doing something, you may eventually have a computer doing it. And so I think it's going to touch everything. Mm-hmm. And I think that it's going to be very interesting to see what happens moving forward with that. And I don't have a great answer about what's going to happen because it's still pretty new.
Right. Maybe our current laws will have to definitely evolve. I know for copyright law, you have to have a human author in order to get protection over that, the work. So it's interesting if an AI or a code is the actual creator, who has the copyright to that.
Exactly.
And I don't think that's answered right now in the current law, so that's something that will have to be considered moving forward.
Yeah, I think it's going to be something we'll probably see in the courts first. I'm sure they'll act before Congress. and they'll probably try to make a rule, but I don't know. Like anything else, that's going to be more murky than if the copyright laws are altered in some way to account for that in a way that people couldn't have contemplated whenever they were written.
And Congress they are currently working on updating the Patent Act right now, aren't they?
So the patent laws were pretty dynamically changed in 2011. Mm-hmm. And it changed a lot of things about the law. With respect to this topic, I don't think so. Right. I don't know of anything at this point.
Do you have any advice for those who are interested in becoming IP attorneys?
I think if you have the interest in the underlying art that is being protected by the IP, that's a great place to start. And I, especially being a person with a science background, encourage people to strongly consider it if they have a science background as well. On the other hand, I think if you really don't like those things, you might not want to pursue that because I think you will have to deal with it every day. I think there are ways to gain experience through, especially for copyright and trademark, through law school clinics. I was in the IP clinic at my law school, and we did a lot with trademark and copyright. It's a little harder to do patent work in a clinic setting due to the amount of time those things take. They're not really well set up for a year program. I went the pretty typical route of being a summer associate at a firm. If that's not something that's interested or available, I think there are different organizations in DC that do work in the patent space as far as policy, as far as smaller firms that really focus on one type of procedure, a type of patent review at the patent office. It's called an inter partes review. that have probably a slightly different business model than big firms, and they are smaller just so they have a different dynamic than big firms, which could be a great environment for someone interested in that. And then, of course, there's so many different government agencies where IP intersects. I mean, even at, places like Department of Justice, I know, Commerce. So there are, other ways to, in the public sector also explore these areas from a totally different perspective than I've had.
Well, thank you so much, John, for joining us today, and to the DC Bar for hosting us.
Yeah, thank you for having me.
Thank you.